I'm Keith Becker from Dee Rentals. One of the saddest situations you'll deal with as a landlord is the death of a tenant. From a personal basis, it's a tragedy. There's a tremendous loss. And from an operational basis, there are regulatory obligations that come into play that can be quite complex. In today's discussion, we'll talk about the issue of disclosure. California Civil Code 1710.2 identifies the death of a resident on the premises of your rental property as a material fact. Now, a material fact is considered to be a detail that would influence the inclination of a prospective renter to either rent the property or how much would they be willing to pay to rent the property. Therefore, you, as the landlord or property manager, are obligated to disclose details associated with the fact of someone passing on the property. Now, that someone, in most instances, it could be a tenant, but it could also be the tenant's guest or one of the other occupants, or it could even be an uninvited intruder. As far as within the premises, if you have a condo unit and somebody passed away in the pool house, that's not in the premises. If you have a duplex and somebody passed away next door, that's not in the premises. Within the premises is the residence itself, four walls within that unit. Now, you are obligated to disclose for a period of 3 years the fact that someone did pass away within the property. I would put it into your marketing. You do not have to put in specific and tremendous detail, but you do want to put into your marketing specific information involved regarding this property. Please ask for details. Certainly make sure that you put into the contract, into the rental contract, the disclosure that tenant is notified that within the past 3 years an individual passed away on the property. Now, the last issue associated with 1710.2 is that if an applicant/tenant asks what the circumstances were, you are obligated to be honest and accurate. So if somebody passed away from a heart attack, you obviously should tell them that. If it was a suicide or a violent act, you should tell them that also. Now, bearing in mind, if you try to be circumspect about this, you've got to realize they'll find out from the neighbors anyway. So you want to be clear. Not only that, but the law requires that you be clear. Regarding the law, if you are not thorough and accurate in this, a tenant/applicant could be entitled to the difference between what they're paying for rent versus what they consider the rent to be worth. Knowing that difference, knowing that issue that someone has passed away. How do you calculate that value between those two? That's where it gets very expensive because you start pulling in experts and legal witnesses and so forth. You don't want to go there, so you do want to disclose. There is one final detail regarding 1710.2, and that is there is a special provision about disclosure, and you have to disclose what the specific circumstances are regarding someone passing away unless they passed away from AIDS. In that instance, you still have to indicate that someone passed away, but if someone asks what were the circumstances, you're under no obligation. Furthermore, you shouldn't disclose the fact that it was AIDS related. That is one of the special provisions associated with this California Civil Code provision. Property management can be a challenging and complex business. If you have any questions on this or any other subject, please call us at Dee Rentals.